What starts as a routine plea hearing quickly turns into a courtroom showdown over one critical issue. What exactly is this defendant admitting to, and what is she refusing to admit? Today's case involves theft allegations, disputed restitution, changing names in court records, and a judge who is clearly not willing to rubber stamp paperwork just to move things along. The defendant stands accused under one name, identified under another, and enters court hoping to resolve the matter through a no-contest plea. But then everything changes when the defense tries to challenge parts of the evidence while still asking the court to accept the plea deal. Now here's why this matters. In criminal court, a plea agreement is not just a formality, it's a legal contract. The judge must know exactly what facts are being admitted, what issues remain disputed, and whether the defendant truly understands the consequences. If those lines get blurred, the whole deal can collapse instantly. Watch closely as this hearing turns from a simple theft plea into a battle over restitution, legal strategy, and courtroom procedure. The judge is asking one simple question: can you plead no contest while refusing to stipulate to the evidence? And the answer may cost the defendant the entire deal. Stay with us, because this gets tense fast.
That if y'all are not stipulating to anything, then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea. Is calling 2024 CR 011624 State versus Jan Hawkins, aka Jan Madura. Can I have parties announced?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura.
And are you Miss Madura?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA as Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay, is my understanding.
Okay, because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madura?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count one. We're proceeding on a lesser included of count two.
And what are you proceeding on?
On a Class A theft.
No objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in all the, electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a Class A misdemeanor? Range of punishment is anywhere, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were...
At this stage, the judge is doing what every careful court should do, making sure the defendant is entering the plea knowingly, voluntarily, and competently. That means confirming she understands the charge, the punishment range, the rights she's giving up, and the consequences if deferred adjudication is later revoked. This isn't just routine questioning, it protects the record from future appeals claiming confusion or coercion. Notice how thorough the judge is here. Jury trial rights, cross-examination rights, the right to remain silent, immigration consequences, all covered. That tells you the court is trying to make this plea airtight. But ironically, even after all this groundwork, the real issue hasn't even surfaced yet. The paperwork may be complete, but the agreement itself is about to fall apart. Question for you. If someone wants the benefit of a plea deal, should they have to fully accept the evidence behind it? Or should they be allowed to challenge parts of it later? Let me know below.
Revoked. The court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Miss Maduro, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and the right to re-enter the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Your Honor, we understand that we can address the court on the any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
That's the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Now we arrive at the money issue, and this is where many criminal cases become far more complicated than the charge itself. The state is recommending 2 years deferred adjudication, but also restitution payments to multiple parties, including Berkshire Hathaway and Visa. That means alleged financial losses may go beyond the original complainant. Restitution can be one of the most contested parts of sentencing because it raises major questions. Who was actually harmed? How much loss was directly caused by the offense? And should third parties like insurers or credit companies be reimbursed through criminal court or forced to sue in civil court instead? The defense clearly sees danger here. Even if the defendant avoids jail, a large restitution order can become the real punishment. That's why they're preparing to fight the numbers. Smart strategy, or delaying accountability, depends on how you see it. But one thing is certain, the financial battle is just beginning.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. They're recommending restitution to Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We'll offer Exhibit 1 with all attachments.
No objections, Your Honor.
Right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, that means that the state will be presenting witnesses in the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here?
Well, I am going to ask to a restitution hearing.
Okay.
And the fact, these stipulations.
And here comes the turning point of the entire hearing. The defense appears to have crossed out language saying the stipulated evidence is true and correct, while still wanting the plea accepted. To the judge, that creates a massive legal contradiction. Why? Because if the defendant won't stipulate to the evidence, then what exactly is the plea based on? A no-contest plea means the defendant is not formally admitting guilt, but is accepting conviction without fighting the charge. However, courts still need a factual basis. Judges cannot simply guess what evidence is reliable, while both sides argue over the foundation. That's why the judge pushes back hard here. This is a classic courtroom collision. Defense counsel trying to preserve objections, judge demanding procedural clarity, and honestly, both sides have a point. But in this courtroom, only one opinion matters: the judge's.
You can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So y'all will have to correct your paperwork.
Judge, if I may, we've done this before. We are
Not
pleading
with
no.
me.
Actually, I have on one prior plea, on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provide purpose, having us do. We've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the junior league.
Well, Judge, she doesn't have to stipulate to it. No, she's pleading no contest. And so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the junior league.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have at the very
That's why you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings, and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well, that's where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this: if she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league, because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever, that's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise,
listen carefully to what the judge is saying now, because this is the legal heart of the case. If nothing is stipulated, then everything is contested. That means no clean plea, no efficient resolution, and no shortcut to sentencing. The court would need to hear evidence, evaluate credibility, and potentially turn this simple plea hearing into a mini-trial. From the defense perspective, they want to accept the plea while preserving the right to challenge the larger restitution amounts. But the judge is drawing a line between contesting money issues and contesting the underlying evidence itself. Those are two very different things. This moment shows why courtroom wording matters. One crossed-out phrase on a document can derail an entire agreement. Many people think cases are won with dramatic speeches, but often they're won or lost with paperwork. Would you have rewritten the forms earlier to avoid this blow-up? Or was the defense right to stand firm?
If you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then you all
amount.
need to change your paper.
And Your Honor, I know to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence, and the judge can look at that and decide that they find those documents credible and find that they are true, and
I can't do any of that if y'all are not stipulating to anything. Then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you
All right.
accept if we just simply put on that we do
Oh,
not
y'all
stipulate to the final amount?
Y'all do the paperwork. And if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the
There's no
thing. I haven't read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount, so we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn.
In the end, this hearing became a powerful lesson in how criminal procedure works. What looked like a straightforward theft plea unraveled because the parties were not aligned on one essential issue, whether the defendant was accepting the evidence or challenging it. The judge refused to accept a plea built on unclear or altered sworn documents and ordered the paperwork redone properly. That's a reminder that judges are not there to simply approve deals. They must protect the integrity of the process. The broader takeaway? In court, precision matters. Names matter. Language matters. Signatures matter. And when restitution, evidence, and admissions are mixed together carelessly, even a negotiated plea can collapse in seconds. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Document.
We can do that, Judge.
Okay.
Thank you.
So, yes.